Safeguards have you and your staff put into place to make sure that your political role and your official role are not overlapping?
My decision is grounded in the evidence that was presented and reviewed by the hearing, and the neutral hearing officer issued recommendations grounded in the evidence and the laws of the state of Maine. It is my duty to uphold the law and the Constitution, and that is what I have done.
Any comments on whether or not to recuse yourself from this process or any part of your official role as Secretary of State?
It's not a surprise that many opponents want me to step down as Secretary of State, but I haven't backed down even under threat and harassment, and I'm not backing down now from doing my job and following the law and the Constitution.
Should your staff have caught this earlier?
Are there other questions?
Do you understand why people are rattled by this decision and the perception of a conflict?
So are there questions from the media?
Yeah, has this happened before? Petition has been invalidated in such a way?
I can't speak to that history, but I can certainly ask my career election staff to review that and circle back with you afterward. And I think to the question of whether these mistakes should have been found in the initial review process, I think the issue of the actions of out-of-state circulators who left their petitions unattended and the affidavits that were supplied by witnesses as well as photographic evidence is not something that would have come through in the initial process. That is something that is an opportunity available after remand with the hearing process. Similarly, the circulator who allegedly forged signatures, for whom every signature on a sheet was made in the name of another, where affidavits by individuals who did not sign that form and by the clerk who spoke to voters who had not signed that form, that is evidence that could not have emerged in the initial review absent those voters coming to the Secretary of State's office, but the review after remand, the hearing process, did create an opportunity for a voter to come forward and say under oath that in fact she had not signed the petition. And further affidavit from Clerk Dillingham indicating that all of the signatures on a particular petition form for one circulator were found to be invalid because they had not been made by the voters in that jurisdiction.
And just to be clear, there's nothing wrong with being from out of state and being a circulator or being paid for signature, right? It's just that they didn't follow our laws.
Right. So initially, under the Maine Constitution, out-of-staters were not permitted to circulate petitions. And initially, under the Maine Constitution, circulators were not permitted to be paid. However, litigation around the initiative process has resulted in courts ruling that out-of-state circulators may in fact gather signatures and that they may in fact be paid per signature. What happened in this case is that out-of-state circulators failed to agree to abide by the laws of Maine, and at least 2 circulators did not abide by the laws of Maine.
How many signatures are we talking between the two?
Yeah, we can provide that detail. I've got it right here if you want me to walk through it, or I can just give you the sheet of paper.
Well, I was just curious if it was enough to totally push it over, or if it was...
So, I think we've got the
that's in
full
the release.
decision.
Okay.
Yes. Actually, do you have
Well, if it's in the
the
release.
detail? It is in the
Yeah,
release.
okay.
Yep. So a line-by-line analysis of the signatures that were eliminated is in as an attachment to the release. You
Okay.
see the revised decision, and there is a parenthetical for each category as to how many signatures were eliminated after remand.
Perfect, thank you.
Yeah.
Can you specify what the arguments that were rejected due to lack of evidence as noted in the press release?
So there was one circulator who collected at a Christmas event in Auburn who was photographed with his back to the line. He was passing petitions along a line of people at a particular event. But it was unclear that he was not, in fact, aware of who was signing. And so we did actually permit those signatures to move forward as valid signatures because there was no evidence that he left the event or left the petitions. And so it was a matter of perspective on whether he was, in fact, present and witnessing those petitions.
Do you feel like this process raises any concerns about the process itself? Are there any recommendations to avoid something that's happening again, or? imprudence? Like
We certainly have discussed how important it is that those trying to bring a citizen initiative train their circulators, particularly out-of-staters who may be unfamiliar with Maine law. My election staff sat down for multiple hours with those spearheading this particular initiative to walk them through the law and the requirements in detail. Unfortunately, out-of-state circulators either did not adhere to training provided by those leading the initiative, or those leading the initiative failed to train their out-of-state circulators sufficiently to avoid the legal problems that have resulted in validating the petition.
Can you elaborate on what happens if they have indicated they challenge the petition, they have 10 days, and then does it go back and forth between the Superior Court and your office? What happens?
The Superior Court may do three things. They may uphold our decision, in which case it will not go to the ballot. They may remand for further review as to a particular point if there is a dispute between the parties that the court finds is not complete, or they may place the petition on the ballot, rejecting the decision of the Secretary.
Will the petitioners get an opportunity to get more signatures?
Yes, and that has happened before, in fact, with at least one of the marijuana referenda, where if the court upholds my decision to invalidate the petition for the November ballot, they may still collect additional signatures to qualify for a future ballot. Under the law, there is an annual deadline to qualify for that year's ballot, and there is a deadline after which signatures are no longer valid. So signatures may not be more than a year old, and the deadline for the November 2027 ballot would be next winter.
But it couldn't get on this fall if they have extra.
It could not.
So
Only the court could overrule our recommendation.
putting your governor's cap back on.
No, I can't.
No.
I'm not speaking as governor or candidate here today. I'm
Okay.
just speaking as secretary. I
Okay.
can't speak to anything else.
So you're totally prepared for the Republican ads and all that stuff, okay.
Nothing outside of my role as secretary has entered into this decision. My decision is grounded in the facts, the evidence, and the arguments that were presented by my professional staff, as well as the two parties who submitted legal briefs on Saturday night.
So no matter how bad you get attacked, you can't respond?
Nothing that is occurring outside of the Office of Secretary of State entered into this decision, nor will it.
Do you think the validation process should change at all now as a result of all this? Will change in that?
I think this shows the process worked. My staff did a preliminary review of what was before them. The remand resulted in a hearing where additional evidence was presented, and a failure to follow the law by at least two circulators demonstrated that there were insufficient signatures to qualify the petition for the November ballot.
It seems like this was a fairly complicated review process. Was it further complicated by the fact that the Constitution and state statute actually says that out-of-state petitioners are not allowed, and that you're actually relying not on law or the Constitution, but the consent decree between the previous effort and your office? How complicated is that when you're dealing with a consent decree that doesn't line up with the Constitution or statute?
It is certainly confusing to people that portions of the Maine Constitution have been found by a court to be unconstitutional under the federal law. And the legislature has not moved forward with updating the statute to reflect what the federal Constitution says, because people simply disagree. Many legislators and many members of the public think out-of-staters shouldn't be permitted to gather signatures. However, they are permitted to under the U.S. Constitution. Now, the court, when they struck down the portion of the Maine Constitution as unconstitutional, remanded that particular decision to a lower court, and we entered into a consent decree, and the court did in fact say that we could put in place processes to safeguard the integrity of the petition process. Those processes include a form whereby circulators must attest that they submit to the jurisdiction of the laws of the state of Maine, and multiple circulators did not. Additionally, all circulators, whether they're out of state or in state, must witness the signatures that they collect and in fact must swear to that in an oath. And at least 2 circulators did not swear to that oath correctly because they in fact did not witness the signatures that were on the petition forms that were submitted to the Secretary of State.
Do you expect any criminal referrals in this case?
I can't speak to that.
So your office hasn't made any yet?
No,
There was no mention of that in the...
I can't speak to that.
possible.
Yeah.
And just to walk back through the process, would the selection of the Chief Deputy Secretary of State to run the process, is that how it normally would work, or would the Secretary of State?
So we appoint different hearing officers all of the time. There was a recent case of a challenge to a county sheriff in York County, and the director of elections oversaw that particular hearing, made a recommendation to me that I upheld after arguments from the parties. Similarly, there is another challenge to another sheriff's candidate being held next week, and that is being overseen by the deputy for elections. So it is very common practice that the hearing officer is staff to the Secretary of State making a recommendation to the Secretary that I then uphold or reject.
So it wasn't a situation where, because you're running for governor, you
No.
asked her to...
No. It's very common that these hearings are overseen by other staff. Yep. Great. Any other questions? Jackie, I know you want to do a specific stand-up. That's fine.
Hold on, Jackie. I need to get a cut of you.
Oh.
Yeah, me on the ground.
Okay, you have any questions?
No, I mean, you kind of alluded to this. You're running for governor. I know you've taken President Donald
I
Trump
can't
off the
speak.
ballot.
I can't speak to anything outside of this office. My decision was grounded in the evidence and the facts that were presented at the hearing, the recommendation from my staff, and the arguments made by the 2 parties.
Madam Secretary, can you explain why you won't take a question from the main wire, but you'll take a question from everybody else?
I will take questions from the main press. I will not take questions from parties, including folks who have submitted recommendations to me regarding this particular initiative. It would be inappropriate for me to be engaged with advocates at this time. Any other questions from members of the press? Okay, great. Thanks, guys.